Hello everybody. So in this video we are going to discuss Article 22 that deals with protection against arrest and detention in certain cases. So this article falls under right to life category, and this is the last article under that category. There are 3 other articles on which we already have made videos. If you need, you can check the playlist and watch these 3 articles as well. Prior to this, we already have covered right to life as well, and thereafter we will get into right against exploitation. Speaking about Article 22, this provides protection against arrest and detention. Means once an individual has been arrested by the police, what rights do he or she has, right? What legal process police needs to follow, what are the safeguards that are available against the detainee's disposal. So these are the things that we are going to cover under Article 22. So let us get into next slide and let us see what Article 22 talks about. So Article 22 does have 7 clauses, right? And while this information loads, let me declare at very outset that information on this slide does not limit only to Laxmikant, because gone are the days when most of the polity questions could be attempted only by covering Laxmikant. So you need to make sure that you need to have detailed and in-depth information, and that's what these slides are doing, right? So it may sound little detailed and lengthy, but it will give you that cutting edge that is necessary to clear prelims and mains both, right? So make sure that you watch all these videos. So having said that, Clause 1 and 2 of Article 22 provide safeguard to those arrested under punitive detention, right? So there are 2 kinds of detention, one punitive, another preventive detention. So I am not getting into the details. I hope, I assume that you already know that, right? Now clause 3. So clause 3 tells you that who are the category or class of people who cannot have these safeguards mentioned under clause 1 and 2. Thereafter clause 4, 5, 6, these 3 clauses deals with preventive detention, and the 7th clause tells you about parliamentary power in relation to enacting the laws for the preventive detention. These 3 clauses, right? So I hope you have now an structure at least, right, that what these 7 clause deals with. Now let us get into next slide and let us discuss these clauses separately, right? So these are just a notable feature of this Article 22. So heading reads protection against arrest and detention in certain cases. So certain cases is in red and bold because the safeguard that has been mentioned, right, those are not available in few cases. It is not available in all the cases, and that's why certain cases. I'll let you know that in which all cases the safeguard that we did just discussed, those safeguards cannot be availed, right? So let us discuss the features of Article 22. So the first feature is that it provides you procedural safeguards against arbitrary arrest. So how it will provide procedural safeguard against arbitrary arrest, that we will see in clause 1 and 2, that what are the rights that you do have, what process police needs to follow during arresting you, what are the information. So this is what this deals with. Then this protection is all available only against state action and not private individual. One more additional information along with this, which this slide doesn't have, that this right is available to both citizens as well as foreigners. Next information. So next information that deals with punitive and preventive detention both, right? We already have dealt it. Punitive detention clause 1 and 2 we already have seen. Preventive detention 4, 5, 6. Then what could be the grounds of preventive detention? So preventive detention can be on grounds of security of state, public order, in maintenance of essential supply and services, and then in foreign relations. So on these accounts Parliament can come up with laws providing for preventive detention. So next clause is that union and state both have concurrent power over the legislation while dealing with preventive detention, right? So both states and union can make laws in relation to preventive detention, right? So let us move to the next slide and let us see the 3 clauses, clause 1, 2 and 3 on this slide. So clause 1 and 2, it deals with, so while police, while arresting you, it needs to let you know that on what grounds you are being arrested, and it needs to provide you the legal advice, means availability of lawyer, right? So clause 2, not more than 24 hours without magistrate permission. So what is the rationale behind it? See, police when it arrests you, right, it is a party to that act, right? So their rationale over the arrest cannot be believed. They can act in a biased manner, they can act in an arbitrary manner, right? So their version cannot be believed. So you need a neutral person, and that neutral person can be magistrate. So police needs to produce you within 24 hours of the arrest, right, except the transit time. So if the Delhi police arrests some person any criminal, right, in Karnataka, and it is bringing that person from Karnataka to Delhi by a train. So that train time, that commutation time will not be counted. Once you are in Delhi, thereafter in 24 hours he needs to be produced. So this is clause 1. Clause 2, inform the grounds and allow him legal access, and then not more than 24 hours without magistrate permission, right. So clause 3. So what are the category of people who cannot enjoy these rights? That has been dealt in clause 3. So clause 3, so these are enemy aliens and those arrested under preventive detention do not enjoy these rights. There are other areas as well in which these two clauses, these safeguards mentioned under these two clauses are not available, and this is the area, right. So if you have been arrested on the orders of the court, right, or if you have been arrested on the order of court for the violation of any contract, in that case you cannot enjoy these 4 clauses, because again understand the rationale, right. So court already, after looking into the merit of the case, right, has issued a order to arrest you to the police. So police when coming, it is not coming in an arbitrary manner, it does hold a warrant, it does hold a order. So in that case, right, that's why that certain cases, protection under certain cases, if you remember the heading, right. So safeguard under clause 1 and 2 is also not available to those arrested in pursuance of court order or arrested for the violation to pay any income tax or for the violation of any contract. So I hope you do have clarity on clause 1, clause 2 and clause 3. So let us move to the next slide and let us see what clause 4, clause 5 and clause 6 deals with. So the common thread that will run along these 3 clauses, that I already told you that these 3 clauses are going to deal with preventive detention. So having that information, let us discuss clause 4, 5, 6 separately. So clause 4 reads, if you can see on the screen, if preventive detention has to be extended beyond 3 months and if the acts permit so, right. So let us break this line and let us see what is written between the line. So what it is says that if acts permit so, right. What does this essentially mean? This means that to have preventive detention, state needs to come up with an act, right. If it has to take effect, preventive detention can't be arbitrary, right. It can't be that executive just one day decide, or magistrate of a district just one day decides, right, and he arrests somebody and puts him or her into the preventive detention. There has to be a legislative basis, and that will come through act, right. So if 3 months, if the detention has to be extended beyond 3 months and if the acts permit so, still the opinion of the advisory board consisting of high court judges or ex high court judges or the person who are qualified to do so, their opinion is necessary, right. So if you remember or if you are following the current affair, Mehbooba Mufti and Omar Abdullah's, for the first time when they were arrested after this J&K bifurcation, they were arrested under preventive detention for first 3 months. Thereafter their extension has been by this procedure, and right now they are arrested under Public Safety Act, because the act there in J&K perhaps do not allow extension of their arrest beyond perhaps 6 months or 7 months. That's why they have been arrested now under different act, right. So I hope you would have understood clause 4. Let us get to the clause 5. So clause 5 deals with the right of the person, those who are arrested under preventive detention. So those who has been arrested under preventive detention, right, they also do have those normal rights that is available to those under preventive detention, and the rights of legal representation, right. You need to have a copy of arrest. So these kind of rights that is dealt in clause 5. Let us get into clause 6, and clause 6 reads that there are certain grounds when it comes to security of state or defense, right. So there are certain grounds on which these informations, these rights mentioned in clause 5 cannot be provided to those arrested under preventive detention. So let us move to the next slide and let us see what clause 7 deals with. So clause 7 deals with parliamentary power to regulate these preventive detention laws, and you will see that under pursuance of this power, this very power, right, you will have many laws that parliament has come up with since independence, right. So I have not mentioned all the acts or all the preventive detention acts, right, but there are certain notable acts on this slide, right, that I have noted down. So you will see this APSPA that have been effect from 1958, then UAPA, Unlawful Activities Prevention Act, right, then Coffee Cosa Act, right, this is in short format called Coffee Cosa Act. Thereafter you have National Security Act 1980, and there are certain acts that stands repealed, right. So this MISA had been brought during that emergency, that was repealed by as soon that Janta government came into the power. Then you had POTA, TADA dealing with the terrorist activities, right. So these three rights now stands repealed. This Coffee Cosa is nothing but economic version of this MISA, although this is in operation, right. So I hope you do have clarity on all the 7 clauses, right, because that we have done in a structured manner. Once revise it and you will be over with article 22. This video has already been lengthened, so I am not going to lengthen it further. So for article 22, bye bye, good night.